So Jode Millman's program, she, as many of you have read, is an attorney in New York, and she's an award-winning author, a podcaster, and a book reviewer. And she will cover the basics of copyright, trademark, and key provisions of publishing contracts to help you understand the fine print without having a law degree. She was educated in Syracuse at Syracuse University and NYU Law School, and she taught at Detroit Mercy Law School and at Marist College. So please welcome Jode Millman. Thank you.
Thank you, Joan. Okay, good evening, everyone. Thank you for inviting me. My name is Jode Millman, as Joan just said. I'm an attorney. I live in Poughkeepsie, New York. I'm also a crime fiction writer. I have a new book coming out in April called Hooker Avenue. But before we talk about me, let's talk about you. So what I'm going to do is I'm going to share my screen. All right, well, welcome to the Writers Law School. And we're going to talk this evening about protecting your artistic rights. Some of the things we're going to be covering include intellectual property, copyright registration, fair use, public domain, business entities, and publishing contracts. Now, what is intellectual property? It really is three categories of creative works. And basically, they're provided with special protections by the government, which is really kind of a very cool thing. We've got copyrights, we've got patents, and we've got trademarks. We're going to discuss what is the difference of each one of these categories and what does each protect. First, we're going to start with copyrights because that's something as writers we're most interested in. Copyright protects an original work of authorship. And I want you to remember that from the moment that you put your fingers on the keyboard, the moment you pick up your pen and put it on a piece of paper, you are the author and you have created an original work of authorship. Some of the other things that copyright protects are literary works, books, finished products, films, musical works, sound recordings, broadcast paintings, and blogs. And they're all protected by the US Code Title 17. Now, who is a copyright owner? A copyright owner is the author of the work. That's you, the copyright owner, except when you're a work for hire. A work for hire means that, let's say you work for a company that has you writing books or has you taking photographs or drawing pieces of art. Then that work that you create within the purview and scope of your employment is not an original work of ownership. You are merely a work for hire. And as a result, you're not entitled to individual copyright protection for your work. One thing I really want you to keep in mind is that merely coming up with an idea does not make you an author. And one of the things I also want to mention is you're going to see as I go through my presentation, I have these wonderful slides, and they're from a comic book copywriting seminar that I took through the New York State Bar Association. So again, as we get into this program and I talk a little bit about fair use, I'm using these in connection with educating you on copyright. Now, what is a copyright and what does copyright protect? Well, first of all, we have our little copyright golem here. Isn't he cute? Now, what we have the right to do as an author or an artist is we have the right to copy him, okay? We have the right to make copies. We have the right to distribute copies of that work. We have, if we're a playwright, we have the right to publicly perform the work, or a film director, or someone who's created a film. We have the right, if we're an artist, to publicly display the work. And we also have the right for derivative works. Now, what is a derivative work? A derivative work is when you take the initial work of copyright and you do spin-offs. So for example, we have our copyright golem. We could make a comic book out of him, a TV, a movie, a video game, or a toy. It's when you take the original work and you expand it into other avenues. Now, as I said before, one thing that you really have to keep in mind is that you cannot copyright an idea. And I can't tell you how many times I get asked this question. You cannot copyright an idea. And to prove my point, let's talk about William Shakespeare's Romeo and Juliet. We all know that the basis underlying trope is star-crossed lovers. Now, you take that trope, and it's been used throughout history in other works of music, film, art. For example, West Side Story, star-crossed lovers, Twilight, star-crossed lovers, Outlander, Titanic. All of these people have taken this idea and then made an original work of art, original characters, original plot lines, and they have been able to obtain copyright protection as a result on their original creation. Again, you can copyright your own creation, but you cannot copyright, excuse me, my mail popped up here. I don't know why that did that, because I closed it. Whoop, are we lost here? No, I'm going to go back to this presentation.
We're fine. We're fine. It's just,
there we go.
It has to be full screen.
There we go.
Okay, there you go.
Yeah, I don't know why my mail popped up out of nowhere because I turned it off. Well, as I said, you can copyright your unique creation. Now, here's an interesting point. I was reading an article in the New York Times about copywriting cookbooks. Now, for any of you writers of cookbooks out there, you know that this is a common problem. Who owns the recipes? Now, no one does, because under the copyright law, they view recipes as a list of ingredients. They don't view it as anything like a poem or a short story or anything that's entitled to copyright protection. The creative way that people get copyrights on cookbooks is they add little stories about their family. They add creative photographs. They add little twists, and they make the book actually itself a work of art that is entitled to copyright protection. And again, if you're going to be borrowing someone's recipe to include in your cookbook, be sure that you give some type of credit to source, so that someone knows that this is not your original group of ingredients. But it's really kind of interesting that these poor cookbook writers are not entitled to actual copyright protection of their recipes. And apparently it's very common in that industry for people to swap recipes. I mean, how many types of recipes are there for beef bourguignon? But everybody remembers Julia Child's, but there are tons of them. So just remember, if you're doing it, it's the creative works around your recipe that are entitled to protection. Another thing that's not entitled to protection is your website. You have to remember that. However, the artwork, the stories, the material, everything that you put on your website can be individually copywritten. So let's look at some of the key rights in copyright. First of all, it's really easy to create. How do you do it? You go to www.copyright.gov. There's a simple form. You can fill it out online. You can do snail mail, and then you pay your $45 for your application, and boom, you have your copyright certificate and you're in good condition. Now, one thing about copyright, it lasts the life of the artist plus 70 years. So it is something that you can put in your estate and put in your will, so because it will be a benefit to your heirs and assigns. And technically, no registration is required. You don't have to file with the Copyright Office. I always recommend to people that they do it because it's that extra layer of added protection, and I'll show you what I mean. What are some of the benefits of copyright protection? Well, first of all, it puts the public on notice that you are the owner of this piece of work. It's a legal evidence of your ownership in that particular work, whether it's a piece of art or it's a book or short story or photograph. when you have this certificate and you have this registration, it's prima facie validity. In other words, it shows the world on its face that you've gone ahead, you've applied, and it is absolutely bulletproof, it's valid. One thing that you can also do is it brings you the ability to bring on an infringement action, which is something you cannot do if you have not registered your copyright. And it provides you with maximization of damages. Now, not everybody is J.K. Rowling, and not everybody can afford to pay, let's say, $500 to apply to federal court to protect your copyrights, or they don't have the money to hire an attorney to go ahead and protect their copyrights. And I mean, it could be a very long, prolonged, and expensive process if you go to federal court. However, there's a new case procedure. It's a small claims case procedure, which has been created by the Copyright Office. It was included within, remember back in 2020, we had one of the very first COVID protection bills. Well, this was snuck in that 5,900 page document. It created a tribunal that allows people who have claims of less than $20,000 to go ahead and apply to this tribunal for infringement in the event that someone steals your property, steals your copyright. And right now, if you go to www.copyright.gov, you'll see they've already appointed the people who are going to be sitting on the tribunal. They're in the process of going ahead and setting up the rules and regulations, which are going to govern the operation of the tribunal. And I'm suspecting that by the end of this year, by the end of 2022, people will be able to apply and go ahead and have their hearing before this tribunal. Again, it will not have the expensive application fees. You will have to be registered for your copyright. You have to pay your $45, but you don't have to be represented by an attorney. So it was really well worth it to make that investment in yourself by doing this registration. So as I said, where do you register? Copyright.gov. Now, it's $45 to go ahead and do a single registration. People nowadays, though, are blogging. They're writing short stories. They're publishing things online. So the Copyright Office has also created what's known as a group registration. So if you have a work that's between 50 words and 17,500 words, the Copyright Office gives you the opportunity, if those works are published within 3 months, to go ahead and file a group registration. So let's say you're a poet or you're a short story writer. You can go ahead, clump them together. If they've been out on your website or in the internet within that 3-month period, pay your $65 and go ahead and file for the group registration. Now, you have to be patient if you apply for your certificate. It does take about 12 months to get the certificate. They're backlogged by like every other government agency. But if you do it online, I suggest you print out your form, because that form in itself shows that you've paid your fee. And from that moment on, you should consider yourself covered by registration. Now, no matter what you do, no matter whether you register or not, put a little C with a circle around it, our little copyright bug, and your name and the date, as I have it here. This is the proper template, 2022 Jode Susan Millman. That you should put that on the title page of any work that you're going to be sending out. And mostly I think I'm talking to writers. So go ahead, you put that on your title page. So whoever you send it to knows that you recognize that you have rights in your particular work of authorship. Again, C, copyright bug, 2022, and your name. Now, we're going to switch gears a little bit. Now, what's a trademark? Where a copyright protects a work that's artistic, a trademark protects a work that's commercial. That's the way that you think about it. If you look at our little screen here, we've got Levi, VW, Oreo cookies, Canon, Pop-Tarts, Calvin Klein, IBM. Those are all logos which identify a unique product that is in commerce. Now, as I said, it could be a symbol a word, or some kind of logo. It also applies if it's a service mark. A service mark is something that pertains to a group. For example, I belong to the Romance Writers of America. Now, they have the right to register their trademark because they have a product. They print it on things, but they also provide services to authors. They have grants. They have educational programs. They have all kinds of seminars. So they provide a service to the public. So they would be entitled to what's known as a service mark. So if you see down here, R with a circle, registered trademark, TM, unregistered trademark, SM, unregistered service mark. Now, what can a trademark be used for? Well, characters. For example, Harry Potter, he's a trademarked character. Mickey Mouse, Winnie the Pooh, they're all trademarked characters. It cannot be used for an individual work. And I'd like to use the example of Diana Gabaldon's Outlander series. She could go ahead and get a trademark for the Outlander series, but she could not get a trademark for Outlander, which is the title of her first book, because that's the way trademarks work. Distinctive logos, we just talked about that, and distinctive costumes. So for example, if you go to Disney World and you see, there's a standard Snow White costume, and there's a Cinderella costume and a Mickey Mouse costume, all those things could be trademarked. Now we're going to shift to the scientific realm. And what is a patent? Well, a patent protects inventions, and just like trademarks. You would go to the United States Trademark and Patent Office in order to apply for an application there. A trademark is something you could really do yourself. And I always tell people that if you're applying for a trademark or service mark, do it on the state level, like New York State, because it's so much cheaper. It's like $50. You contact the Secretary of State up in Albany, you fill out some forms, and you send it up to Albany. Otherwise, again, if you go into the federal system, to the trademark office, it's going to cost a lot of money. And generally, you have to get a graphic artist who's going to help you with their special application. So especially if you're applying for a patent. If you're applying for a patent, you have to have a patent attorney work with you on this application. Now, what is a patent? A patent covers, there are three different kinds of patents. And first of all, patents only cover things that happen in the United States and its territories. Where copyrights are worldwide, trademarks are worldwide, patents are limited to the United States territories. So keep that in mind. We have three kinds of patents. The first, as we know, is a patent for a mechanical device. That's very scientific. That's called a utility patent. The next type, and it's also for improvements on utility patents. Let's say an example would be a drug manufacturer and how they keep tweaking their formulas. They would be entitled to a different type of patent for each type of improvement on their product. The next type is called a design patent. And I always like to refer to this little butter hub. I bought this on Amazon. I was looking for a butter dish, and this company went ahead and created a butter dish, which is supposedly different. You see, it's got little feet to hold the cover, in place. And it's got a magnet on top that allows you to attach your knife. It comes with a knife, by the way. But this is a design patent. So it's an improvement on an existing design. Oh, and if you look at this very closely, you'll see it says patent pending. So this is a design patent, a new fork, a new spoon, something like that. Our third type relates to plant patents. If you go ahead and you create an asexual type of new rose, or a clematis or a peony, you would be entitled to patent protection. So we have our utility patents, our design patents, our plant patents, which are scientific, our trademarks, which relate to commercial, our service marks relate to commercial. And again, going back to our original artistic works, we have our copyrights. Now, I'm returning back to copyrights because that's something that we're all really interested in. And the question is, what happens when you have a work that's copyright has expired? Well, January 1st of every year is known as Public Domain Day. That means that there's a new class on January 1st of works that enter the public domain. That means their copyrights have expired. So anybody that wants to use their work doesn't have to pay any royalties, doesn't have to get any approval or permission from the original copyright owner. This year in 2022, the works from 1925 and before entered the public domain. So as I said, the public can use these works without obtaining permission from the copyright owner. Now, here are some classics that entered 2022. It also pertains to films and it pertains to music, but we're going to talk a little bit about some of the books that enter the public domain. Winnie the Pooh, The Sun Also Rises, Langston Hughes' The Weary Blues, T.E. Lawrence, The Seven Pillars of Wisdom, which was the basis for Lawrence of Arabia. The original Bambi came into the public domain. Agatha Christie went into the public domain. So as you can see, some real heavy hitters have lost their estates, have lost the rights under the public domain. Now, this one really, really shocked me. Now, I didn't know this, but in 2021, Winnie the Pooh was one of the largest grossing franchises of the year. It was the third behind Pokemon, Hello Kitty, and it was tied with Mickey Mouse. So that means since the underlying work of Winnie the Pooh entered the public domain, so does its characters. Pooh, Tigger, Piglet, Eeyore, Owl, Kango, Christopher Robin, they all went into the public domain. So now what happens when we have someone like Walt Disney who has a trademark on certain aspects of our friend Winnie the Pooh? It creates a conflict between the copyright and the derivative works. So this is when we talk about derivative works. Remember, I mentioned that a few minutes ago, because Disney is only entitled to copyright protection and trademark protection on new items that it added to the original copyright. So for example, the original drawings of Winnie the Pooh are in the public domain. However, Disney's interpretation of Winnie the Pooh does not. They have films, as you know, of Winnie the Pooh. A lot of us have watched them with our children. Some of those copyrights on those films continue, as do some of the trademark rights when it does not when it's very specific to a line of clothing, for example. But in general, unless it is something unique that Disney has brought into the mix, then it's in the public domain. And we really have to keep an eye on this issue because in 2024, Steamboat Willie is entering the public domain. And as we all know, Steamboat Willie is the predecessor and actually the grandfather of Mickey Mouse. And you can bet that they're going to be fighting pretty hard to keep their protection over Mickey. So, okay, we got all this public domain stuff. What can we do with it? Well, for example, we could make T-shirts if we wanted. And last year in 2021, The Great Gatsby entered the public domain. So anybody can make a T-shirt that says it's better to burn out than fade away. And the year before, in 2020, Blowin' in the Wind went into the public domain. So we can make a T-shirt that says, how many years can some people exist before they're allowed to be free? So on the flip side of this is, okay, let's suppose that you do have a copyright. Can somebody use any of your material? Well, the answer is yes, under certain circumstances, when it's used for non-commercial uses and for nonprofit purposes. So for example, I've been using those, the slides from the comic books. And those weren't anything I created. However, I'm using them for nonprofit and educational purposes. So I'm entitled to do that. Now, often there's a question as to whether or not something is fair use or not. And quite often it does go to court. So these four factors are things that the courts will consider in determining whether a property has been used fairly. For example, as I said, is it used for educational purposes, for criticism, or even parody? Is the nature of the copyright factual as opposed to creative? How much has been used? We can really only use a tiny portion. You can't plagiarize a whole book and claim you're doing it for fair use. And it can't have any impact or very little impact on the commerciability of that work that you're using. So for example, if you're a professor and you want to use quotes from someone else's book, you can only use a little bit. You can't go ahead and print out without paying them, getting permission because their work is copywritten. Now, in brief, fair use can be used for criticism. And here's poor Charlie Brown for parody as well. And here are some really interesting examples of fair use. Well, for example, there was this group that was there was a DJ, and what she did was she took and she did a mashup of different parts of other songs, and she reordered them to make her own song. So that was considered a new composition, and it was fair use. There was a guy who played video games, and just like he would do goofy things while he was playing video games, somebody else's copywritten video games, and he would videotape himself as he was playing all these games because it had a humorous effect and was basically a parody. That's fair use. Anytime you see something by Ken Burns, that is fair use, because what he does is he takes old photographs or old films, and what he does is he puts them together and he creates a new documentary, and he's doing it, he does it for nonprofit purposes. So anytime you see something like Ken Burns, you can think, he's using those photographs and those images under fair use. And then Shepard Fairey, he's a very interesting guy. And I think you'll all recognize this. On the right, we have the Hope poster, which was an artwork created by Shepard Fairey. And what he would do is he would take photographs and then make creative works out of them. But you see, he didn't change them at all. He took this AP photograph, turned it into a silkscreen. And of course, the AP went bananas over this. So they sued Fairey. So it was a question of copyright versus fair use versus work for hire. Because what Shepard Fairey is saying is, hey, it's a photograph. He's a public image. It's a public, it's been in all the newspapers. I grabbed it off the internet. I'm just making, adding my creative work to it. Well, the courts didn't buy that because the original copyright owner is the Associated Press. Now, up pops the third person in this, a gentleman named Manny Garcia. And he's saying, wait a second, I'm the part-time photographer who happened to take this photograph. And this ties back to what I spoke to about being a work for hire. No, Manny, you don't own this. You were working and you took this photograph while you were working for the AP. So the AP owns this photograph. So how did we resolve this issue? It turns out that Fairey and the AP reached a settlement. The AP agreed to license the image to Fairey for his posters, for his books, for whatever he was doing, for his postcards, and they were going to split the proceeds. So you see, it's really interesting. I mean, especially from an attorney's point of view, when you have these different types of issues of law and how they clash and how they have to be very flexible with one another. Okay, now we're going to talk about libel and defamation. Libel and there's two types of defamation. Slander, which is the tangible form. That's writing, printing, pictures. As I've shown here, examples are magazines, the internet, a blog, and an article. And it's when you say something against some person that maligns them. You're saying something that you know is false, that you know is holding them up to a defamatory light. The other type of defamation is slander. And remember, S, for spoken word. That's, for example, a speech, a news broadcast. And I like this cartoon, Sue the Author. I really like that. So anyway, we have defamation. And as writers, these are things that we have to take into consideration. Especially if you're writing nonfiction, you don't want to be accused of defaming anyone. You don't want to be accused of knowing a secret about someone and putting it in print, something that they don't want to know, which holds them up to public ridicule. And even as fiction writers, we have to be aware of libel and slander. And I put this picture up because a lot of people like to incorporate real life people into their stories. And I always use the example of The Paris Wife by Paula McLean, where she writes a fictional / nonfiction story about the relationship between Hadley and Ernest Hemingway. And she really takes the heart of the characters, but goes big with them, so that as readers, we don't know really what is true about these characters or what is false about them. So if I was writing a story about the billionaires here, about Bezos and about Richard Branson, and I wanted to include their names, I always tell people to go big or go home, because otherwise you don't want them turning around and suing you for slander. One thing you should know, though, is that there's a case called the New York Times versus Sullivan, and it does hold public figures to a higher standard of proof. They have to show that there was malice aforethought in going ahead and writing something derogatory about them, that it was done in order to defame them. It's a very high bar. And as a matter of fact, there was a recent case that I've been looking at, which I'll probably incorporate in the future. It's Sarah Palin's case against the New York Times, where she sued them and they said something, they retracted it, they apologized, but she went ahead and she sued them anyway, claiming it was libel, and the court dismissed it. So I think we're going to see more law developing in protecting the First Amendment rights. Now, let's jump to creating a business. If you're a writer, you have several options. The first is that you could write, let's say, Jode Millman doing business as Jode Millman. I can be an individual. I could also form what's known as a limited liability company. If I'm worried about libeling someone, or I want to just protect my rights. And then there's a corporation, and there are partnerships. A partnership you would use when you're co-writing something with someone. And I always tell people, for example, if you're a writer and you're working with an illustrator, or you are two people, you see like Preston and Childs, they write together. Some people write alternate chapters, some people work together. Louise Penny and Hillary Clinton, they had a partnership. And if you have a long range partnership with someone, it's always better to put what your understanding is in writing, so that should things go south, you know how to terminate the relationship, you know who would keep the, you would determine how your royalties are split in the future. If you want to be an individual and just have a DBA, you can file that in your county clerk's office. You fill out a little piece of paper, you can file it there. An LLC gets filed with the Department of State, as does a corporation. An LLC you can really do yourself, and a corporation, but generally people like to consult an attorney before they form an LLC or a corporation. And even with a partnership, it's always better to have an attorney give their input when you're creating a business. Now, again, why would we form a company? Well, first of all, it's going to limit our liability. It's going to protect our assets, right? And if you form a company, you sign documents, every document has to be signed in the name of that particular entity. So for example, my business company is called JS Millman LLC. When I sign publishing related contracts, I always sign in the name of my company. And as I said, your LLC must be filed with the state as a corporation as well. Now, the publishing contract, woohoo! Well, first of all, congratulations if you've been offered one, because it's like a unicorn, it's a rare thing. But what is a publishing agreement? It's an agreement that you enter into with your publishing company, it's binding, which really specifies the terms and conditions of your deal, of your relationship. It clarifies the terms so that when both of you enter this relationship, both parties are protected. And it also provides ramifications in the event there's a breach. Now, what are some of the key provisions? Well, first of all, what is the work that's being covered by this contract? Is it for a single book? Is it a series? Will they have the right to any spin-offs? Do they have the right to a first refusal on any future books? Do they have an option on any future books that you produce, either related or unrelated to the books that you're signing on for? What is the grant of rights? Are you giving them audiobook rights, video rights, foreign rights, book club rights? There's a whole rainbow of rights that are included generally in a publishing agreement. And also, what is the territory? Is it just English-speaking languages, or is it the world? And is it exclusive? If you want to write short stories for someone else, do you have the right to go ahead and do that? Or are you bound to give everything to this particular company? Also, what is the manuscript delivery date? That's something that's always clearly set forth in your agreement. And that generally the requirement is that the author submit the manuscripts to the company at a particular time. It's an acceptable manuscript. It can't be a piece of garbage. It has to be something that's in publishable form. And again, who owns the copyright? Danger Will Robinson. Remember that at all times, you as the author want to retain your copyrights. There is one time where you probably won't retain your copyright, and that would be in the event you sign on with a company that's going to do your audiobook rights. There's a P with a circle, that's a phonographic copyright. And generally that's in the name of the publishing company. And so, but just remember that you have to put something in there that in the event the agreement ends and both parties go their separate ways, or when the agreement ends, that you will get those rights back as well. And these are generally provisions which are obligations of the author. And one thing to also remember is that when a contract is written by a publishing company, it's written in favor of the publishing house. So as a savvy person, a savvy author, you have the right to go to them to clarify it, to change it, to reach an agreement that both of you can live with. So now here are some provisions which are obligations of the publisher. Well, first of all, how and when will it be published? Will it be published in hardback, paperback, as I said, audiobook? Will it be an ebook? All of that will be specified. Also, when will it be published? Will it be published within 12 months from the date that you give them the manuscript, or on or about a specific date? Another thing is royalties, and I'm going to skip ahead here. We're going to come back to this slide, because royalties are the payment that you receive from the publisher on each sale. And people always say, okay, how much does an author earn? And I found these charts which really kind of symbolize how little authors have a tendency to earn on a book. For example, if a hardcover is $28, and the average royalty that an author receives is 15%. That means that the potential earnings on a hardcover book is $4.20. Now, as you can see, the publisher will earn 14, but the rest of it is for production costs. It costs quite a bit between the publicity, the paper, the transportation, the artwork, the editing. There are a lot of costs that go into putting a book together. And that's why the author receives such a small royalty. Now, in this particular instance, let's say that you receive a $10,000 advance on your book. So that would mean that if they're going to print 5,000 copies of your book at $28, okay, In order for you to receive, you have a potential on 5,000 books of earning $21,000. If they give you $10,000 up front, you will have to sell $10,000 worth of books before you receive another penny of royalties. Okay, so that's just and if you look at the bar charts I have here, you again can see the blue portion is the author's percentage, and the largest percentage is the orange, which goes to the retailer, which goes to the distributor, and the production costs, and then the publisher's profit. So this is something that generally they're not negotiable about. I mean, 15% is usually what the going rate is. And if you get that, you'll be doing okay. Now, another thing that should be in the contract is how are they going to promote your book? And I can tell you from personal experience, 90% of the promotion of a book is going to be on you, the author, which is great. It's a ton of fun, but it's time consuming and it can be expensive. So just remember going in that you're going to have to be your own publicist, your own promoter in order to sell books and to build your brand. But again, that's increasing the sales. That's also increasing the goodwill in your book. And this contract should also have termination clause. So if the author doesn't live up to his or her obligations and the publisher doesn't live up to their obligations, both parties can walk away from this agreement. Oop, there we go. So there are some additional terms I want you to keep in mind. Okay, also keep the right to revise your manuscript because you want to be able to make changes in the You don't want to get it back, having them rearranged it, having your main character be Susie, and the next thing you know, they've changed it to Charlene. You want some kind of creative control over your product. Also, you want to have some kind of input on the cover, the title, and the interior design of the book. That's really important. As I said, control over your editorial changes. You also want the ability to audit them for your royalties. So for example, generally your royalties are issued to you on a quarterly basis. So you want to make sure, generally they'll give you, like an Excel spreadsheet showing you what the income is. If that doesn't look right to you, you want to reserve the right to be able to bring an accountant in to look at their books for your particular work so that you can satisfy yourself that it's that you're receiving the right amount of royalties. Also, define what is out of print because most contracts say this contract will go on forever until the book is out of print. Well, today books are an e-print, so they never go out of print. But so what you have to do is tie it to if 25 copies haven't been sold within the past 6 months. Tie it to something like that, something that's tangible, that's definite, so that will determine a book is out of print if it has not sold 25 copies within the past 6 months. Also, with net receipts, it's important for you to determine what they can deduct from the royalties as expenses. So, you want to make sure you get your $4.20 and that's not constantly chiseled away by copying costs, or runner costs or FedEx costs. You want to be able to make sure that what they're deducting works for you. So I'm going to give you a few quick do's and don'ts. First of all, do as an author know your long-term goals when you're going into your relationship with your publisher. In other words, is it going to be a short-term relationship? Is it going to be for one book? Or do you want to develop a series and have a long-term relationship with this publishing company? That's key. Please, please, please read the entire agreement. And if you don't understand it, get an attorney. Contact the Authors Guild. They have a whole slew of attorneys there, especially if you're a member. They will review a contract for you for free. They'll make some suggestions which allow you to become an educated consumer and go back to the publishing company and negotiate some points. Also, ensure the agreement is the accurate reflection of what you and the company have decided upon. In other words, if it's not in writing and it's not put in there, if they say they're going to take an ad out in the book review section of the New York Times for your book, you want it in there. It can't just be a verbal promise, because that disappears into smoke if it's not in that agreement. And don't be afraid to revise and renegotiate. They're not going to walk away. They expect it. They expect you to come to them, and they expect you to have changes to that agreement. And I can't tell you how many times people contact me. They say, well, I have an agreement. I'm not happy with this. I wasn't represented at the time. Can I change it? The answer is no. The agreement, once it's in writing, once you put your John Hancock on the bottom line, it's there. You live with it. And once you have your agreement, put it in a safe place. You know, what I generally do is, today everything is like in DocuSign. You know, you'll get documents in DocuSign. I always print off a hard copy, and I store it, you know, with my life insurance and my car titles and things like that. And the birth certificates and my copyright certificates, just because I know that I've got them in a safe place. So those are some do's that I want you to do. Some don'ts: never sign a contract without reviewing it. Get everything in writing. This is kind of the flip side of what I just said. Never assume any term is agreed upon unless it's in that agreement. And one more do: if you do need help, contact a lawyer, or if you have an agent, have your agent negotiate your contract and review the deal. So here are some resources for you. These are some of the things that some of the places which I've suggested you look at in connection with what we've discussed this evening. For example, the Copyright Office, www.copyright.gov. Not only do they have copyright information, there's, you know, the registration certificates. There's a lot of information there. You know, we have our tribunal. They list what can and cannot be copywritten. As I said, the forms are there. It really is a wealth of information at that website. The fair use is at standard.edu in case you want to know more about fair use. The Authors Guild's a great organization. They, if you become a member, they design a free website for you. And for the first year or so, I don't even think they charge you for it. And they've got all kinds of webinars and programs that are designed for writers. They had one today on tax tips for writers, what happens when you get rejected. I mean, just all kinds of really great programs. And as I said, they'll review a contract for you for free. If you're more interested in public domain, that's duke.edu. If you find you're in a legal bind and you're looking for an attorney to represent you, especially if you're in New York, it's Volunteer Lawyers for the Arts. Great organization, and they provide services for free. So they're great people to talk to. And again, if you go to my website, I've got blogs, which on most of the topics that I've discussed tonight. So if you're interested in more about Winnie the Pooh and trademark, or about the case legislation, or about copyrights or anything like that, I've written blogs, and some of that information is available for you. Now, I've done a little handout which summarizes these, which summarizes the program, and it also has these references and where to look for things. If you're interested, you can go ahead and email me at jodesusanmillman@gmail.com. And what I'm going to do is, after I'm done with the program, I'm going to exit this slide presentation, and then we'll go back to Joan, and then we can answer any questions that you have. And I will put this email address in the chat box, so you'll have it. So again, jodesusanmillman@gmail.com. That's my website, Jode Millman. If you want to follow me, I'm on Goodreads, Instagram, Facebook, I'm everywhere. And as an attorney, I have to say, the information I presented today is for informational, educational purposes. And just general information. And I hope that you've learned something. I hope you've enjoyed it. So I am going to stop sharing. Okay. And then we're going to go back to the program. There we are.
We did it. Thank you. You've already gotten people thanking you. That it was a great presentation.
Oh, wonderful.
So it went very, very well. I wish I was a writer. I now know exactly how to proceed.
Well, there's always time, Joan. There's always time.
That's true. So, so Jody has put her email address and all the other information. So if you're interested, please copy it down. And if not, we have videotaped this program. So it's available on our website, which is chappaqua.library.org. And you'll be able to view it as many times as you like. Because
Yay.
that's the way sometimes people like to do it. They see it, then they look at it again, then they just internalize it. And sometimes that's the best way to do it. So
Well,
thank you, Jody.
There was a lot of information here. And
You certainly did, and your graphics are beautiful, but there was a lot of information. And you know, it's so interesting you're talking about the copyrights, because that's a big thing at the library with programming. So heed all those warnings she gave you. They're very, very important. Very important.
It's been a pleasure.
So,
thanks so much for having me.
okay, well, thank you very much, Jody. And for everybody, don't forget, we have all the library programs coming up. This program has been videotaped. You can get everything you want on our website, which is chappaqua.library.org. Thank you, Jody. It's been a pleasure meeting you, and thank you all for coming.
Good night.
Bye.